And recording is in progress. Hi, everyone. I have with me today Eric Berg, who is an academic law librarian on the East Coast at Drexel, and Rita Young, who is at K&L Gates, a law firm. And I, of course, am Jocelyn Stillwell Tong. You know me as a former NoCal president, and as the librarian at the 6th District Court of Appeals for California. I am looking forward to talking with all of you today about legal ethics. If I could ask everybody to just take a moment and check and make sure, if you're not one of my presenters, could you be sure that you have your mute on? We will be happy to take questions throughout. If anybody wants to chime in, just raise your hand or put a note in the chat, and we'll make sure that we weave you into the discussion as it happens. But for now, I'm going to turn it over to Eric, who's going to kick us off as academics kick off everyone's legal careers. And he's going to share a PowerPoint with us. So over to you, Eric.
Thank you, Jocelyn. Thank you for having me. So I want to talk about legal research and ethics from my end in the classroom by talking a bit about how I integrate legal research and ethics into my advanced legal research class. So this is a slide that I show my students. We all agree that legal research is important, otherwise they wouldn't be there. But I ask them to think about why research is so important to the practice of law. And what I stress to them is that the practice of law is an information profession. Law is a service profession. We know that lawyers are not selling people tangible goods. And the services that lawyers provide are all dependent, or really mostly consist of information in some way, whether they're delivering advice to clients or communicating their client's position to others. And those services require them to hone their ability to find, verify, and communicate accurate legal information. And what I stress to them is that those services they provide as attorneys can implicate several rules under the rules of professional conduct. But two that I focus on in my lectures are Model Rule of Professional Conduct 1.1, the duty of competency, and RPC 3.3, the duty of candor to the tribunal. And also RPC 1.1 includes a duty of technology competence, which is an emerging area of legal ethics. RPC 1.1 states that a lawyer shall provide competent representation to a client, and that competent representation requires the legal knowledge, skill, thoroughness, and preparation that's reasonably necessary for the lawyer to represent the client. So that doesn't mean that they have to know everything off the top of their heads, but when a client asks them a question that they don't know the answer to, they should be able to be intellectually humble and tell them, I don't know, that's a good question, let me get back to you. And then they need to assess what they know, what they don't know, and can they bridge that gap with effective research and preparation so that they can answer that question or represent that client effectively in that situation. So what they really need to know is not necessarily the answer to every question, but where to find the information that they need to give themselves that knowledge that's necessary to effectively represent the client. I also stress with them Rule 3.3, candor to the tribunal. That states that a lawyer shall not knowingly fail to disclose to a court legal authority in the controlling jurisdiction that the lawyer knows is directly adverse to the position of their client and not disclosed by opposing counsel. So bottom line, adverse authority has to be disclosed to the court, no matter how bad it is for you, no matter how much you don't like it. And note that that covers authority in the controlling jurisdiction, not limited necessarily to just controlling or binding case law in that jurisdiction. And so this is an exercise that I give my students. And it's based on a recent case that was actually is still being litigated against Rutgers University over its vaccine mandate. But in my hypo, they represent a group of students and faculty at a fictional university, Pennsylvania Commonwealth University, or PCU. And that university is public. It's required vaccinations for all faculty, staff, and students subject to medical and religious exemptions. And they've filed a suit in the Eastern District of Pennsylvania. And the judge assigned to the case happens to be an adjunct professor at the law school. So their clients want to file a motion to get this judge to recuse himself because that seems like a conflict of interest to them, right? The judge is a professor at this law school. How can he fairly hear this case? So I asked them to research this. Does a judge have to recuse himself if he's an adjunct professor at this university? And I asked them to just each find one on-point case from a court within the Third Circuit. Doesn't have to be a published or reported case, just one authority each, and give them a few minutes to work on that, to brainstorm search terms together. For instance, you might want to incorporate adjunct, professor, instructor into their search terms. I don't need to tell you all this, but this is the process the students are going to go through to try to find a case. And what invariably happens is within just a few minutes, my students come up with a host of examples here. There are several cases on point within the Third Circuit from both the district court level and from the Third Circuit itself that speak to this issue. And then I show them that in this recent case involving Rutgers, someone did actually file that motion. And when the plaintiff filed that motion, they did not cite any of these cases in their brief. And so you get an admonishment here in the opinion where the court cautions. I think that the judge was pretty mild here. He cautioned the plaintiff's counsel with respect to the thoroughness of their motion and reminded them of their duty under Rule 3.3. And the court trusts counsel will redouble his efforts to discharge his duties in the future. You don't want to have an admonishment like that against you in an opinion. And of course, we know there's other consequences that can potentially come about from poor research, from potential liability to legal malpractice to maybe even in rarer situations, attorney discipline, although I don't think that would be as common. And another newer duty that we're facing too is the duty of technology competence. This comes about from an amendment to RPC 1.1, adding comment 8. To maintain the requisite knowledge and skill that a lawyer needs to be competent to represent a client, they have to keep abreast not only of changes in the law and its practice, but also the benefit and risks associated with relevant technology. This duty of technology competence has been adopted by 40 states as of this month. There's a link here in my slides to a survey that Bob Ambrogi does to keep track of this. And there's a lot of ways that you can integrate this into the classroom or into presentations to attorneys if you're a firm or court librarian. There are applications such as redacting documents. I did a workshop on how to redact PDFs to show students how to do that. This applies to cybersecurity and your duty of confidentiality. And it applies to e-discovery and the use of AI for doc review. So there's a lot of ways to bring this duty of technology competence up with students or with lawyers, again, if you're a firm or a court librarian. And why is this so important to talk about legal ethics issues in a legal research class or in a research presentation? Well, I believe it's pedagogically important because it makes research relevant to real world situations. But if that's not reason enough for you, consider the recent revision to ABA Standard 303B. For those of you who are academic librarians, this standard now says that a law school shall provide substantial opportunities for students to develop a professional identity. And there's a new interpretation to go along with this 3035, stating professional identity focuses on what it means to be a lawyer and the special obligations that lawyers have to their clients and society. So that really opens up, I think, this discussion of legal research and ethics beyond just some of the things that relate strictly to the rules of professional conduct, and out into some other issues that touch on the role of lawyers in society more broadly and the kind of duties that lawyers owe to society, because they have this sort of superpower that of doing legal research, going into court, and being able to represent people's interests. So I want to end by talking about some other ethics issues you can go over. One of them that does relate to their duties under the RPC is working on incorporating billing and not overbilling into your research discussions with them. And if you are on the academic side and you are assigning students a project, you can have a component of that project be to have them complete a timesheet. And you can include some reflection there on whether the time they spent was productive. What do they think? And would they discount their hours? And you can get some good reflection from the students there on how they can do their research more efficiently next time. Another ethics issue that may relate to the RPCs is the use of Westlaw and Lexis, other information vendors, by ICE, and those vendors cooperating with ICE. This can implicate attorneys' duty of confidentiality, as well as their duty to supervise third-party vendors. And Sarah Lambdan, if you haven't read her work, has written some great articles about this, which when you get a copy of my slides, there's a little selected bibliography there. I highly recommend reading her. And beyond the RPC and relating to those issues of lawyers in society more broadly, they might want to consider things like algorithmic bias. You can teach them issues about prisoner access to legal materials. And as part of an access to justice, access to legal information unit, you can cover things like PACER and other docket fees and copyright claims on primary legal materials, like the Georgia Code annotated in the recent Supreme Court case, publicresource.org, or copyrighted standards being incorporated very commonly into codes like building codes. I think that might be sort of the next frontier of that publicresource.org line of cases, if it ends up being a line of cases. So, with that, I want to welcome Jocelyn and Rita into the discussion and stop lecturing and just open this up, make this a little more informal so we can get some perspectives here from the firm side and from the court library side too.
I think we were planning to segue into to Rita talking a little bit about law firm research and legal ethics and communicating with attorneys on that. I think that copyright is kind of a natural first stop on that particular train, because that's one of the things that when I was still a law firm librarian and even now as a court librarian, I have to communicate with our practicing attorneys about very frequently. And I just saw a call for, hey, do you guys have a standard language that you send out about copyright that just went out, I believe, on the GLL listserv. So over to you, Rita.
Thanks, Jocelyn, and thanks, Eric, for that great foundational start for our discussion. And Leading in with the copyright discussion, my firm is one of the more diligent firms that I've ever worked for. This is firm number 3 um, about copyright. We have a very, very strong policy regarding use of copyright, and not only for the attorneys, but for everyone throughout the firm. Anytime we send out a document to an attorney, we have to use the copyright language in our signature, letting them know that we have licensed use to use this within the firm. A lot of times, and our firm attorneys are pretty good about complying with the policy, as they should be, because we get a lot of copyright requests as a result. Oftentimes, I will send a document out, and because of that copyright warning, I will get attorneys emailing me back and saying, may I share this with the client? Does that include sharing with the client? And I have to explain, no. One of the more trickier ones is when we do background reports on individuals, and it's rather long report, and they want to share it with the client, and I tell them the best that you can do is read it to them over the phone. I can't tell you how many attorneys I've had pushback on that and say, you've got to be kidding. And I hand them the firm policy on copyright and say, we're licensed, we're restricted, we can't share it with the client. I said I can direct them to our vendor's contact that they can purchase the access and get the report themselves, but we can't share a copy with them. Also, in preparing for this lecture, I was reminded of the famed and now old Qualcomm versus Broadcom case, e-discovery issues. And it was an early and glaring example of attorneys not knowing and not checking what their technology was doing and how suitable it was for the job for which they obtained it. This has never been brought more to bear when it comes to the new advanced technology that we're seeing now with our vendors, the legal analytics aspect of the research component databases that we have. This has troubled me greatly. Frankly, I was one of the few people who, when Westlaw Next came out, stood up and said, you've destroyed legal research as we now know it, because it made it very easy to not question the algorithm that was running behind the search. When you built your own Boolean search, and I am one of those who still does it, it's very rare that I just rest it on a natural language search and hand off results as a result of that search, because I don't trust the algorithm, and they shift the algorithm often enough that someone a week later using that same natural language search may get different results, which causes then questions to arise as to whether we did an adequate search to begin with. So those are reasons enough that when I give them an algorithmic Boolean search string, you're going to get the same results. You might get newer cases added as a result, of course, because the law is always evolving, but your search is still going to be, in the main, pretty consistent. The problem with the analytics I have found is that everyone likes the pictures. The picture tells, 1,000 words, right? But when you look at the underlying analytics, there's a dearth of data there. I actually questioned the analytics for one vendor for intellectual property. That's my Ballywick. And I asked them, where's the data? And they actually wrote back and said, yeah, don't use our analytics for the IP stuff because it's not completely built yet. And that was only 6 months ago. So, and the analytics have been with us for a while. So just to let you know, they're still young and infantile on the vendor side. So we speak those analytics with caution. The other bridge that I often have to straddle, and I'm sure many of you are with this, is when you're doing research that requires you to reach out in person to another third party and you cannot disclose your client. Sometimes you're not allowed to disclose the firm. It's always good practice, a best practice, in fact, that when you have a research that may lead you to speak to a third party regarding the information you're trying to seek, to check with the attorney requesting to make sure that you are allowed to reach out to that vendor or third party and speak about the information that you're looking for. Oftentimes, I may get directed in the research saying, go ahead and speak to them, and I have to ask the attorney, well, when I do, they may ask the following questions. Am I allowed to answer that? I tend to be very shy about saying who I'm working for, and I never disclose the client, no matter what. So sometimes that gets into tricky situations because the third-party vendor may not wish to speak with me at that point. And then I basically have to go back to the attorney and let them know I've done this, but without the further disclosure, are not willing to offer up anything on their end. Perhaps you would like to speak with them. This is who I spoke to, and here's the phone number. The other ethical and legal research pitfall that I face with law firms is actually probably running for many of you in law firms right now, dealing with the summer associates. It is always, we still do, we're one of the firms that are still charging back for our electronic research. And it is always a tricky thing when we get the summer associates in because of the fact that in law schools, they don't see a bill. And I know we've asked vendors, I've personally asked vendors, could you at least put a pseudo $sign charge going up in the small window or on the search bar to let them know theoretically how much this would have cost them. And the vendors are wholly against that for obvious reasons. But we have to teach the client, we have to teach the summer associates just how much their legal research has been. And there's nothing more that makes me wince in pain when I get a summer associate asking for help and telling me that they've literally run 50 different searches and they still can't find something, and they've been looking in an entirely wrong database to begin with. So we have a discussion at that point, and I let them know, well, what made you think to go here? Did someone tell you to go here? And advise them, because this would never be the resource that you would use for this, for the following reasons, and let them know. Sometimes it's because they were curious, because they were told that this database had this, so they went searching, and then of course once they start searching, they can't help themselves. They keep thinking it's their fault that they can't find anything, and sometimes it is, but in certain instances, it's the database or it's the vendor that they picked or the database that they picked that is in error. We always encourage our summer associates to reach out to any of us in the library, and we advise them that we are their first front champions, and we're here to help them succeed, not help them fail. So it's really good working with the summer associates and helping them get their understanding on a broader range of databases also that they may not have exposure to in law school, but we also have to caution them not to share their passwords. Tell them that even if it's helping out a colleague, and collegiate help is always useful, that if they're using online folders, they risk that violation of ethics if they happen to be helping one of their fellow summer associates by sharing a password, and that summer associate is working on something that is behind an ethical wall. And they may not necessarily know that going in, and it may be an innocent oversight. They're not thinking about it. They forgot that that folder is there. But it is something that we have to warn them about, because the appearance of a potential breach of an ethics violation is enough to set off alarms for the firm. So we try to, maintain and assure that all of our summer associates have all the passwords and access points that they need to their research. Fortunately, in the 6 years that I have been here, we haven't had a major ethical violation that has resulted as a result of legal research, either through the library or because of the summer associates. I think it's rare that we get away, any law firm gets away without a large Westlaw bill or Lexis bill as a result of the summers. But fortunately, we've been able to work with the vendors to circumnavigate that from hitting our clients' invoices, as I'm sure you all have. And it's the other interesting ethics issue with copyright is, excuse me, is when we run into the nebulous fair use discussions, because we get requests to use icons in our PowerPoint presentations or cartoons, and these are often copyrighted. And my firm's copyright policy is really clear that permissions must be obtained. And we often get young associates who want to have all of these pictures in their PowerPoint presentations, and we have to tell them, these are copyright protected. You can't use them without permission. And then they find out just how much it costs to get all those permissions. So it can be a very illuminating event for new associates as well, when they find out that even though it's a presentation or a CLE presentation within our firm or externally, it's not fair use because we're a law firm. It's a commercial setting. So that's the legal ethics and legal research intersections that I run into in a law firm.
Yeah, thank you, Rita. I think that was very illuminating. It definitely brought back a lot of memories for me from my time in firms. I have to say, I joined the court in 2013, and I remember when I was doing competitive intelligence at my old firm, which was one of my favorite parts of being a firm librarian. I loved that particular duty. And they were talking a lot about social media and the ethics of looking things up and people searching on social media. And I continue to think that it's just fascinating, the intersections of, I always told my attorneys that as a individual, I was horrified at how much I could find on people, both on social media that they just put out there into the world, and using people search services, which, of course we paid for and then had to have a compelling reason to use legally. But as a firm librarian, I would have loved to have been able to access more because, asset searches are not something that are easy to get your hands on. And there are definitely instances where they're very useful to a firm for sure. So yeah, thank you, Rita, and thank you, Eric. I'm just going to underline a few things that both of you have already talked about while talking about the court perspective on legal ethics and research. Eric spoke a little bit about Model Rule 3.3, I believe it was, the one that is related to the duty of candor towards the court and making sure that you disclose any direct precedent, even if it is possibly detrimental to your client. I just want to say, from the court's perspective, when I first arrived here, I was really astonished at the amount of time and effort and legal research that our research attorneys do as they're helping their justice write an opinion here in the California courts. The California courts are a little different from the federal courts. The federal courts usually have a number of career research attorneys, but then they also have 1 year clerks who come in and work with the courts for a short period of time. Here at the California system, we don't really have the luxury of those 1 year clerks. We just have people who are kind of career researchers, which makes my job fascinating. It's like working with a whole team of law librarians who are each kind of stuck in a specific era of legal research, because of course, all of my attorneys are focused on results and I am the one who's the process expert. But as far as the duty of candor to the court, I think having worked at firms in the past, I know sometimes there's a time crunch. People really just need to get a brief filed before the deadline, and then maybe they'll go back and amend it, and then maybe that amendment never actually happens. You know, hello, I hear an additional person. Just a reminder to everybody, you may want to mute if you're not presenting. Okay, so the attorneys, the judges, they're expert researchers. They will find everything on their own, but if they have to, it hurts your credibility as an attorney. And if you tend to appear in front of the same court repeatedly, your reputation is, you know, it's a form of currency. If you are someone that they are used to seeing sloppy work from, or a firm that they're used to seeing sloppy work from, they're not going to take your briefs as seriously. They're going to redouble their efforts to make sure that they've hit every single case. You know, of course, they do this anyway, but you don't want to go into it with people taking a larger grain of salt towards your brief. On the other hand, if you are someone that they have seen in the past and they've been impressed by your work in the past, and frankly, it doesn't take much at the state appellate court level, because we do see a number of very questionably researched briefs, it does add to your argument. They'll take you more seriously. It adds gravitas to everything that you file if your reputation is good. I'm sorry, Rita, you were going to say something?
Yeah, actually, that brought back also the fact that operating during this time of quarantine and post-pandemic, it's really also brought back the technology competence that's been required. I'm sure all of us have seen the "I'm not a cat, Your Honor" YouTube posting, which, you know, it's not just the legal research that the attorneys have an obligation to, it's the technology that they're using to present their case. And that was really brought to bear during the quarantine. And in fact, it was very interesting to see how fast all the courts scrambled to sort of accommodate, and how fast the ABA, or maybe not how fast the ABA, worked to sort of give some leeway with regard to their rules, because a lot of the attorneys working from home may have been, like, for example, in my state, I'm in Pittsburgh, I'm in the southwestern corner of the state. We have a high population of people who live in Ohio, West Virginia, or even Maryland, and they used to commute into the office, or they had a pied a terre in Pittsburgh and then went home on the weekends. And now all of a sudden they're technically remoting in from work to court appearances from home in their home state that they may or may not be licensed in. And if they're not licensed in, is that practicing law in the state without a license? And under the ABA rules, yeah, under 5.5, as you read it, it would be. So the ABA had to scramble to alleviate that rule. But yes, the use of the technology isn't just in the use of the legal research anymore. It's on all the tools that you have at your disposal to present your argument on behalf of your client, and also all the tools that you have for the documentation to build up the facts of your case are required, which was what the Qualcomm case was really all about. But back to you, Jeff. I'm sorry.
Yeah, no, that's a great point, Rita. It's been a really steep learning curve for our attorneys. And ironically, as with the attorney cat, sometimes people may be up to date in one area and then not as up to date in another area, and not realize until their judge is really trying very hard not to laugh at the fact that they are appearing in court as a cat. I don't think that that was any sort of ethical violation personally, but it definitely brought a lot of people a lot of joy. But I think all of our hearts went out to that poor attorney in that moment. And yeah, but to circle back to the duty of candor toward the court, I did want to mention just a couple of cases that we've seen recently here in our court. We had one come in recently where somebody filed an opinion with absolutely no citations to anything that was relevant. They cited to one statute, which they said actually they misread it. And they said that the company, even though it had been dissolved, had the ability to sue, even though the statute said it had the ability to be sued. And so that was a pretty significant error in reading and citation, and there were no cases supporting it, obviously, because the statute did not say that. Also probably because they didn't look. But when talking with the attorney about that, she said that she thought that anything that was cited by that particular attorney, they may have just read, instead of reading the case, they may have just read the head note on whatever service they got it off of. And yeah, that is not meeting your duty as a counselor of the court. I do have examples of the opposite where people will file things with appendices that are so large as to be not just exhaustive, but incomprehensible. So my example of that one is a recent filing that we got with a legislative history that was 3,000 pages. So obviously the attorney, if you can't point to something in those 3,000 pages yourself that is relevant and actually useful to interpreting the case, the attorney is not going to go through it for you. And in both of these situations where you don't cite enough and where you cite too much, and by you, I mean the attorneys that you work for, you're essentially making the court act as your client's attorney, and they don't want to be in that position. And the reason is that when you're acting as an attorney, you're acting as your client's counselor, and that gives you a certain point of view. And the court needs to be neutral. So we can't take that counselor's point of view, even when it's very tempting because we want to get the case processed, we want to see justice done, we want to get it pushed through the system. You know, timeliness is important on our end too. And so, yeah, that can be an issue, and we all have sympathy towards attorneys that have to be accountable for billable hours, but really, especially at the appellate level, it is important to be thorough. I also wanted to talk just very briefly to underline something that Rita said about remote work. It looks like as technology pushes forward, especially post-pandemic, we all have seen how important it is to be able to access justice from remote places and remote and different points of view. But I wanted to mention that there is this issue of access to justice in rural communities. And I do think that the pandemic has done us a real favor, both technologically and ethically, by making remote appearances so accessible to our colleagues and to the clientele in rural areas. Because I know for my court, for example, we're located in the middle of San Jose, which is the most populous area of our patch of appellate work. But we have counties down all the way to San Benito, which used to be part of the second district, which is based in LA. That's a really large and long patch of land. And I know just since remote appearances have been a thing, our oral arguments have gone up by about 50%. And that really speaks to the fact that people want to be seen and heard by the court, but either time, accessibility, or cost were a major determining factor in whether or not they wanted to have their day of argument in court. I mean, of course, we would still get the briefs, we would still be able to dispense justice, even without an oral argument, but that is really important, not just for persuading the court, which it can sometimes, but also emotionally for the clients to have that day in court and to feel heard. Um, so those are a few things I wanted to talk about from the court perspective. Oh, let me check the time. I do have time for one more item. And just as some more inside baseball, if any of you go in and plan to work in the courts in the future, one ethical issue that we face that was surprising to me when I started is our internal policies related to computer use. Anything that is still in process. Of course, once an opinion is issued, it's free to the public and it's accessible. But until that opinion is issued, it is confidential. And our computer use policies indicate that we are not allowed to upload anything that's a work in process off of our court servers. Now, we've carved out an exception for Brief Check from Lexis and Drafting Assistant from Westlaw to help our judicial assistants make sure everything is good law. And that, because it's just such a time saver, really would have required additional staffing if we weren't using those services. But some of the brief analyzer tools, which started with case texts, CARA, and then evolved with Quick Check and brief analysis, those are just kind of a bridge too far for anything that's a work in progress for our court. And so unfortunately, we're not able to use those. I was really pleased to see that both of the vendors were able to notice this, acknowledge it, and they've put out judicial versions of those materials where you can upload the briefs from either side, and in fact, multiple briefs from either side, and sort of get a map of who is citing to what, and it gives you really a good idea of what cases support what arguments. Hopefully everything that is direct precedent is cited in both, but if they're reaching out to other precedents from other courts and other jurisdictions, you can see who's trending in what direction, and that has been really helpful. But still, the underlying tool, as it was originally meant to be used, is just not accessible to us. And there are a number of things that are like that, where for one reason or another, we just simply can't use it due to internal court policies. For example, the folder sharing function on Lexis and Westlaw, we can't use that because it's too close to, it's sort of storing work in progress outside of our own servers, which, I never would have thought of that, but once I started here, it does make sense. Yeah, so I want to thank Rita and Eric again. It looks like we've got a few minutes left before we get to 10:45. If anybody has any questions or wants to chime in with any interesting stories, I know Eric and Rita and I have all dropped some really interesting links into the chat. So I encourage you to pull up the chat and populate your browser with all kinds of interesting stuff. If you have anything, go ahead and just either raise your hand or drop it in the chat. While you guys are thinking, I'll say that if any of you ever need a excuse to look at Twitter while you're at work, this whole panel kind of arose out of a tweet that somebody had where they were talking about ethics and legal research. And Eric mentioned that he was thinking about spending about 20 minutes in class covering topics on legal research ethics, prisoner access to legal materials, people searching in ICE, the duty of candor to the court, the duty of technology competency, algorithmic bias in various, advanced legal research classes. And I think that's such a fantastic idea. I think our attorneys really need to spend more time thinking about these particular issues. Because so many of them, either are a duty that they have individually as a counselor of the court, or, are just things that they should think about. There are often issues where a vendor may have some behavior that we would think of as unethical, but, any sort of action that we take may be an individual solution to a systemic problem. You know, if they stop providing services, a different vendor that may be less, you know, persuadable will pop up in their absence. So, so these are things to keep in mind. So, all right. I think that's it. I don't see anything in the chat. I don't see any hands up. So I'm going to turn it back over to you, Jeremy.
Thank you, Jocelyn. Thank you, Rita and Eric as well. Much appreciated. Rita, I actually did have a question. Was your copyright policy drafted in conjunction with K&L Gates's Office of the General Counsel?
Yes.
Okay, yeah. So I would say for those of us on the firm side, if you're thinking about developing such a policy, make sure that you run it with the Office of GC, because they're going to give you the cover that you need when these disputes arise.
Yeah, I would have to say that most of our policies do emanate ultimately, like the final seal of approval comes from the GC, and they're the ones who authorize the issuance of the policies to the firm, to the rest of the firm.
That was my experience when I was on the firm side as well. We gave input, but it was really up to the GC's office to finalize all the policies. And we do have GC's offices on the academic side too. So if you're coming up with a copyright policy for your academic library, that's also a consideration there.
Awesome, awesome. Yeah, so thank you again, all of you. Appreciate it. We are going to take another break now for another 15 minutes or so. Come back top of the hour at 11 o'clock for our panel on accessibility with the vendors to see what's new in accessibility in the legal research platforms. Thanks everyone for being here, and we'll see you soon. Take care.